It took exactly 47 seconds to dismantle a 5-decade career. Not with an accusation, but with a date, a signature, and the cold, unblinking authority of a federal court order proving that every word he had spoken under oath was a calculated, deliberate lie against the United States Constitution. The room was the Senate caucus room, a chamber built for intimidation, where the cold majesty of white marble met the relentless glare of television lights. It was not a place for compromise, but for the televised establishment of truth or the systematic destruction of reputation. The air conditioning hummed a low, constant drone, a counterpoint to the shuffling of papers and the incessant clicking of professional camera shutters. Director Ashok Patel of the National Intelligence Assessment Office sat at the witness table, a heavy, dark mahogany slab that seemed to absorb all light and warmth. He looked like what he was, a seasoned bureaucratic warrior, impeccably dressed, his posture rigid, his hands clasped precisely on the polished surface. Senator Eleanor Vance, Democrat Massachusetts, chair of the Select Committee, occupied the central seat. Her expression was less hostile than profoundly disappointed, the kind of professional detachment that often precedes institutional cruelty. The political tone of the hearing, officially titled Oversight of Contingency Funding and Compliance with the Intelligence Authorization Act of 2024, was not about a policy disagreement. It was about integrity. The whispers on the Hill were clear. This was a loyalty test, and Patel had failed. The hook, the shocking opening moment, had already been set in stone by the legal challenge Patel didn't see coming. It took exactly 47 seconds to dismantle a 5-decade career. Not with an accusation, but with a date, a signature, and the cold, unblinking authority of a federal court order proving that every word he had spoken under oath was a calculated, deliberate lie against the United States Constitution. The lights reflecting off the marble floor created a shimmering, almost spectral effect, contrasting with the dark, heavy suits of the senators. Patel's office had been under informal scrutiny for months following whistleblower complaints concerning the rapid, unexplained growth of the agency's Special Access Programs, SAP's, budget. His testimony today was intended to clear the air, to offer technical justifications, to baffle the committee with jargon and complexity. Director Patel, Senator Vance began, her voice a measured, steady mezzo-soprano. You swore an oath not only to tell the truth to this committee but to uphold the laws of the United States. Let us begin with the Intelligence Authorization Act of 2024, Section 301, subsection B. This section explicitly mandates that any interagency transfer exceeding $50 million must receive prior, written approval from the chair and ranking member of both the Senate and House Intelligence Committees. Do you affirm, under oath, that your office adhered to this specific requirement for the $text, $185 million transferred to the Project Sentinel Contingency Fund in Q3 of this fiscal year? Patel leaned slightly into the microphone, the small movement betraying a stiffness in his neck. His voice was smooth, practiced. Thank you, Chairwoman. We have been fully compliant. The funds in question, specifically the $text, $185 million, were designated for mission-critical technical enhancements. Our legal counsel determined that, pursuant to the Presidential Findings Directive, PFD 13-05, those funds fell under an exception for imminent national security threats, exempting them from the Section 301B pre-notification requirement. He offered a subtle, almost imperceptible nod of confidence. It was the precise, legalistic deflection that had saved his career countless times. But the silence that followed, before Senator Vance moved to her notes, was deep enough to drown in. It was the sound of a trap just being set. Senator Vance allowed Patel's answer to hang in the air for a deliberate, uncomfortable 3 seconds before she spoke again. She subtly adjusted her glasses, her eyes remaining fixed on a point just above Patel's head. The committee's legal counsel, a young woman named Ms. Chen, passed a small, pale blue note card to the senator. Patel, whose eyes had been steadily meeting Vance's, allowed a flicker of peripheral vision to dart towards the card, the only evidence of stress in his otherwise controlled composure. Director, Vance continued, her tone now shifting from inquiry to subtle cross-examination. Your reference to PFD 13-05 is duly noted. That directive addresses operational parameters for certain covert actions. It does not, and legally cannot, supersede a specific congressional mandate regarding fiduciary oversight and appropriations transfer. Let me rephrase. Did you, or any member of your immediate staff, submit a formal written request to either this committee or the House Permanent Select Committee on Intelligence regarding the $text $185 million transfer before the transaction was finalized on July 14? Patel maintained his practiced calm, a slight, almost patronizing smile touching the corner of his mouth. Senator, my staff operates under established protocols. Given the highly sensitive nature of Project Sentinel, our internal legal team assessed the PFD 13-05 exemption as superior, due to the doctrine of classified necessity. Our mandate is to protect the nation. Bureaucratic delay, in this context, risks national security. He shifted marginally in his seat, a small movement that appeared intended to assert authority. This was lie number 1, claiming a non-existent legal hierarchy. The Appropriations Clause of the Constitution vests the power of the purse exclusively in Congress. No executive branch PFD can legally circumvent a specific, non-emergency statutory reporting requirement like Section 301B of the Intelligence Authorization Act. Senator Mitchell Reed, RSC, the ranking member, leaned forward, his voice a gravelly, low register, picking up the thread. Director, let's move past the sophistry of PFDs and focus on the plain text of Title 50, U.S. Code, Section 3093B, which governs whistleblower protection and retaliation. We have received detailed testimony from an analyst, identified here only as Source Gamma, alleging that she was demoted and had her security clearance permanently suspended 3 days after raising concerns internally about the Sentinel funding deviation. Senator Reed paused, letting the implication settle. Did you, or any person reporting directly to you, authorize the demotion and clearance suspension of Source Gamma on or about July 17th of this year? Patel's composure wavered, his eyes darting quickly to the left, a common physiological tell for accessing prefabricated or invented information. The flash of the camera bulbs seemed to intensify around him. Senator, I was aware of personnel restructuring within that division. Source Gamma's performance review had been unsatisfactory, long predating any budget query. Her security clearance was suspended following an independent and standard internal audit, entirely unrelated to her operational concerns. I categorically deny any retaliatory action under Title 50. This was lie number 2, fabricating a standard internal audit and denying causality. The documentation supporting Source Gamma's excellent performance reviews, which the committee already held, directly contradicted this claim. This intentional misrepresentation violated the underlying spirit of Title 50, Section 3093B, which prohibits reprisals for lawful disclosures. The tension in the room was palpable, the silence between questions now thick and heavy, punctuated only by the nervous scribbling of reporters' pens. Patel's left hand, resting on the table, exhibited a minuscule tremor, controlled, yet visible under the harsh, unforgiving light. The foundation of his deception was being systematically laid bare, brick by meticulous legal brick. But the silence wasn't over yet. Senator Vance retrieved the blue note card and placed it decisively on the table, a clear visual signal that the conversation was pivoting from budget obfuscation to institutional malfeasance. She took a slow sip of water, her eyes never leaving Patel. Director, let us move from personnel matters to the operational core of Project Sentinel. Your office maintains that Sentinel is an inert data aggregation program, summarizing publicly available threat intelligence. However, this committee has recently received an internal directive, dated May 1, 2025, titled Enhanced Metadata Capture Protocols. Vance held up a single sheet of paper, the edges of the confidential stamp slightly blurred by repeated photocopying. This directive, signed by your Deputy Director, Mr. Kenji, explicitly authorizes the covert insertion of specialized network probes into the traffic nodes of Tier 1 domestic ISPs, specifically targeting metadata related to all VPN and encrypted voice-over IP traffic originating within the continental United States. Patel's jaw tightened. The blood visibly drained from his face, leaving a sickly pallor under the bright lights. He swallowed hard. This document exposed his most significant, most dangerous deception. Vance pressed the legal point with surgical precision. Director, the Foreign Intelligence Surveillance Act, FISA, Section 702, as amended, permits the targeting of non-US persons located outside of the United States. It does not authorize the bulk, warrantless collection of domestic metadata, particularly concerning private, encrypted communications, without a specific, individualized warrant. Moreover, the Fourth Amendment of the Constitution protects against unreasonable searches, requiring probable cause. Did you, or anyone acting under your authority, seek a specific FISA court, FISCR, order to initiate these enhanced metadata capture protocols? Patel finally broke his professional facade. His voice was no longer smooth. It was strained and higher-pitched. Senator, that memo, that specific directive was preliminary and theoretical. No actual deployment of those probes occurred. The $text, $185 million was for the capacity to deploy, should an imminent, severe terrorist threat necessitate it. We were acting under a reasonable interpretation of the Executive Order 12333 umbrella, which broadly governs foreign intelligence activities. Furthermore, metadata is generally considered a business record, not protected under the full scope of the Fourth Amendment. This was lie number 3, denying the actual implementation of the domestic surveillance program and hiding behind a broad, irrelevant executive order. The legal failure here was catastrophic. The implementation of a domestic mass surveillance program without a specific warrant, a clear violation of the Fourth Amendment's protection of privacy against unwarranted government intrusion. Patel's argument that metadata wasn't protected was legally specious, particularly regarding aggregated, encrypted communications data, a standard that had been refined by recent Supreme Court precedent. Senator Ben Harrison, Independent Pennsylvania, a former constitutional law professor, interjected, his voice slow and heavy with intellectual authority. Director, Executive Order 12333 does not, and cannot, grant your agency immunity from the statutory exclusionary rule or the clear limits established by the FISA Amendments Act. We have satellite communications logs showing 3 distinct activation signals sent from the Project Sentinel Command Center to ISP infrastructure nodes on May 15, May 22, and June 4. These signals precisely correlate with the network probe activation codes listed on page 4 of this memo. Which is the truth, Director? The truth you swore to uphold, or the physical evidence of 3 distinct activation signals? Patel stared blankly. He opened his mouth, then closed it. The evidence was irrefutable. His denial of implementation had been legally necessary to avoid the charge of criminal abuse of office, but the committee had the technical receipts. The silence was agonizing. The only sound the mechanical were of the clock counting down to the inevitable climax. But the silence wasn't over yet. The tension was now a physical weight, pressing down on the room. Senator Vance glanced at the clock on the back wall of the chamber, a digital display that read 3:45 p.m. She reached beneath the dais and retrieved a thick, official-looking document bound in a gray cover. This was the hammer. This was the final, irrefutable contradiction that moved Patel's transgression from administrative misjudgment to criminal perjury. Director Patel, Vance stated, her voice dropping to a near whisper, forcing every person in the room to lean forward, your entire defense regarding Project Sentinel's domestic operations rests on 2 premises. First, that no actual deployment occurred, and second, that metadata collection under Executive Order 12333 is legally sufficient. We have now received an authenticated, sealed ruling from the United States District Court for the District of Columbia, pertaining to a separate civil liberties suit filed against your agency. Vance opened the document to a marked page. The chamber was utterly silent, except for the distant whir of a cooling fan. I will read one paragraph from the court's findings of fact and conclusions of law, dated October 19th of this year. We are referencing case number 24 CV 1109, Ames versus National Intelligence Assessment Office. Vance adjusted the microphone and began reading the core finding. The reading took exactly 47 seconds. Vance, reading, slow, measured the court finds, pursuant to subpoenaed and validated network logs, that the defendant, NIAO, did indeed activate 3 distinct metadata capture arrays targeting Tier 1 domestic ISP traffic on May 15, May 22, and June 4, 2025. Crucially, the court further finds that this collection was executed without the requisite judicial authorization or probable cause, specifically violating the Due Process Clause of the Fifth Amendment and the Freedom from Unreasonable Search and Seizure Clause of the Fourth Amendment. Furthermore, the court explicitly ruled that the defendant's invocation of the Executive Order 12333 was legally insufficient to shield this domestic activity, concluding that these actions constituted an unwarranted and systematic governmental intrusion into private communications, resulting in a violation of protected statutory rights under FISA. Vance looked up from the document. The gavel on the dais remained untouched, yet the silence was more profound than any noise. The 47-second moment was over. Patel's carefully constructed composure collapsed. His eyes glazed over, fixed not on Vance, but on the mahogany table. A faint sheen of sweat appeared instantly on his forehead. He instinctively started to rise from his chair, a nervous, involuntary movement, as if trying to flee the cold legal reality just read into the record. "Senator, with respect, that ruling is under," he stammered, his voice cracking, "under appeal. It is not final." "Director Patel," Vance interrupted, her voice now sharp and lethal, "the finding of fact, the act of deployment, is established by a federal court using your own internal data. Your defense, that no deployment occurred, is demonstrably and legally false. When you stated under oath moments ago that the May 1st directive was only theoretical and not implemented, you were committing perjury before this committee, a felony under 18 U.S. Code, Section 1621. Furthermore, the court ruling establishes that the deployment itself was a direct, actionable violation of the Due Process Clause of the Fifth Amendment, undermining the fundamental civil liberties guaranteed to American citizens. Your failure is fatal, Director. It is not merely a policy error, it is a constitutional crime." Patel slumped back into his chair, the movement heavy and defeated. He placed his hands flat on the table, palms down, a final, futile gesture of control. He looked directly at the camera lenses, not seeing the audience, but seeing only the end. But the silence wasn't over yet. The gavel finally fell, a sudden, sharp, percussive sound that broke the profound silence like a gunshot. Senator Vance, visibly shaken but entirely composed, pronounced the conclusion of the testimony. "Director Patel is hereby subpoenaed to provide all physical and electronic records pertaining to Project Sentinel to the committee within 48 hours. This committee will refer the matter of potential perjury to the Department of Justice, DOJ, immediately. This hearing is adjourned." The room instantly erupted into chaos. Reporters surged forward, shouting questions at the retreating figure of Patel, who was being quickly escorted out by his visibly distressed legal counsel and 2 silent, grim-faced security detail members. The noise was overwhelming. The frantic calls of journalists, the rustle of papers, and the sharp, urgent commands of committee staff clearing the area. Outside the chamber, the fallout was instantaneous and seismic. Within the hour, every major news network had cut into their scheduled programming with the headline, "Constitutional Catastrophe, NIA Director Exposed." On the screen, a split image dominated the coverage. On the left, the stone-cold gravity of Senator Vance reading the court document. On the right, the shattered face of Director Patel. News anchor, MSNBC 4:47 seconds. America watched competence collapse. The reading of the Ames v. NIAO ruling was the equivalent of a legal neutron bomb. It confirmed not only that a massive, unwarranted domestic surveillance program was operational, but that the director of the agency lied about it under oath. Constitutional scholars called it the most devastating Senate takedown of an executive official since the revelations concerning the misuse of the FBI during the Nixon administration. Legal expert, CNN, former Deputy Attorney General, the core issue here is not the budget. It's the Due Process Clause of the Fifth Amendment. When a federal court, using the agency's own data, confirms a program violates a foundational constitutional right, and the agency head commits perjury to hide that violation, the breach of public trust is irreparable. The referral to the DOJ for prosecution under 18 U.S. Code, Section 1621, perjury, is now unavoidable. His political career is over, and his legal battle is just beginning. The institutional consequences were swift and brutal. The White House, which had quietly supported Patel until the moment the court ruling was read, issued a terse, 6-line statement accepting Patel's immediate, forced resignation for loss of confidence and reiterating its commitment to the rule of law. The Senate Intelligence Committee immediately voted to freeze all funding for Project Sentinel and launched a full, multi-year, bipartisan investigation into all $text, $185 million of the contingency fund, citing potential criminal waste and abuse of the Appropriations Act. The FBI, anticipating a major criminal investigation, dispatched a special counsel to collect all relevant files from the NIAO, ensuring the chain of custody was untainted for the looming perjury and abuse of office charges. The public reaction was a mixture of outrage and exhaustion. The familiar cycle of Washington deceit confirmed once more. The image of Patel's silent breakdown became a national symbol of a government official placing political ambition above the foundational law of the land. The meticulous planning, the legal complexity, the years of bureaucratic ascension, all vaporized in a 47-second recitation of the truth. But the silence wasn't over yet. The week following Director Patel's collapse became known in Washington as the Great Reassessment. The noise of the media frenzy gradually subsided, leaving behind a cold, institutional reckoning. The criminal referral to the DOJ was formal. The investigation into the abuse of funds and power was underway. The national conversation shifted from who was lying to how the system allowed the lie to become institutionalized. The long-term impact was not on the individual, but on the delicate, fragile balance of power. The exposure of Project Sentinel's domestic surveillance, confirmed by a federal court, created a deep, permanent fissure between the legislative branch and the intelligence community. The Senate immediately began drafting the Congressional Oversight Restoration Act, a comprehensive bill designed to close the Executive Order 12333 loopholes that Patel had attempted to exploit. This new legislation sought to impose strict due process requirements on any intelligence activity touching domestic communications, raising the bar for constitutional compliance far above the agency's historical interpretations. Patel himself disappeared from the public eye. His life was reduced to the confines of his legal defense. His attempt to shield his agency's actions behind a flimsy legal defense, claiming a technical exception for a constitutional violation, was his ultimate downfall. Washington doesn't punish ignorance. It punishes the exposure of calculated recklessness. His reliance on the doctrine of classified necessity to violate the Fourth Amendment was exposed as legal cowardice, not patriotic fervor. The moral of the episode was etched into the marble walls of the Senate caucus room. The law, even when convoluted, remains the ultimate arbiter. Patel had gambled his career on the assumption that the complexity of intelligence operations would shield him from direct legal accountability. He lost because a single federal judge, in a quiet civil ruling, prioritized the sanctity of the Fourth Amendment over political expediency. The truth, in the end, was not a matter of debate but a matter of fact, validated by the very judicial system he thought he could circumvent. The cameras were gone now. The caucus room was quiet, the scent of stale coffee and hot electronics slowly dissipating. An assistant carefully rolled up the thick coaxial cables, returning the room to its intended silence, a place where the law, not personalities, held sway. The mahogany table, once Patel's stage for performance, now stood empty, reflecting only the cool, fluorescent ceiling lights. Some careers end in scandal. His ended in silence. Washington doesn't punish ignorance. It replaces.